We spoke to law professor Greg Wallace, who supported the original bathroom bill and opposed repealing it.
There are things about the repeal that I think are good and acceptable, but I can understand certainly why the LGBT community would be upset with it. The new law is an attempt to return North Carolina to the status quo prior to Charlotte passing its ordinance, which led to the creation of House Bill 2. And I think your reporter accurately summed up the provisions in the bill. Probably the one that would be the most disconcerting to LGBT groups would be the prohibition on local governments from enacting their own non-discrimination laws for a 3-year period.
All right, Professor Wallace, correct me if I'm wrong. You don't think HB2 discriminates against the transgender community, but it does force them to use a bathroom that does not correspond with their gender identity. Explain the distinction there.
Well, the bill is not about hating or targeting transgender persons. It's about respecting long-standing societal norms that protect personal bodily privacy. The reason we have different bathrooms and changing facilities is because we have different bodies, not different gender identities. And House Bill 2 protects the privacy interests that arise from our bodily differences. Now, what transgender activists who are challenging HB2 want is federal courts to declare that the Constitution privileges gender identity over personal privacy in bathrooms and changing facilities. They say that House Bill 2 harms the dignity and privacy of transgender persons, but their way really harms the dignity and privacy of everyone else.
So put privacy aside, do you think transgender people should be protected from discrimination?
I think there are places where transgender persons should be protected from discrimination, but House Bill 2 says that when it comes to bathroom facilities and other changing facilities where there are competing personal privacy interests, that in those spaces, privacy should trump equality.